Hello, everyone. Welcome to our live webinar today, and thank you for joining us. Once again, for those of you who haven't had the opportunity to meet me yet, I am Natalie Gill, the LLM Programs Assistant here at Coastal Law. Joining me is Dean Margaret Ioannidis, Associate Dean of Strategy and Innovation, and Professor Leigh Scales, our guest speaker for the month of March. Before we begin today's presentation, I wanted to remind everyone that we are recording today's webinar, which will be in listen-only mode. The webinar is meant to be interactive, so please send us your questions using the chat feature on the left-hand side of the screen. If you select private to presenters, your question or comment will only be viewed by the presenters. We plan to email everyone who registered for today's event a copy of the slides from today's presentation as well as a link of the recording. And with that, I will turn it over to Dean Margaret Ioannidis.
Thank you very much, Natalie, and thank you to everyone for joining us for today's webinar. We are pleased to have Professor Leigh Scales as our guest speaker today. Professor Scales joined the Florida Coastal School of Law faculty in 2001 and served as the director of the Lawyering Process Program from 2004 to 2013. Her teaching areas include legal ethics and legal research, writing, and oral advocacy. Many of you may already know Professor Scales as your professional responsibility professor in our LLM programs. She also has the distinct honor of teaching professional responsibility in our JD program, and her JD students actually had the second highest scores in the state of Florida on the November 2016 MPRE exam. Prior to joining the faculty, Professor Scales practiced litigation for 7 years in private practice here in Jacksonville, Florida, both with Rogers Towers and Marks Gray. Professor Scales is a member of the Florida Bar, and she's admitted to practice before all Florida courts, as well as the U.S. District Court for the Middle District of Florida. Before I turn things over to Professor Scales, we wanted to run 2 very short surveys to get a better understanding of our audience. If you just give me a moment, we'll go ahead and do that right now. The first question is, if you can please select your background and professional responsibility. Are you currently taking a course in professional responsibility, or have you never taken a course in professional responsibility? All right, so it looks like we had, well, at final count, it was about 38% students are currently taking a course in professional responsibility. About 63% had not taken a course. All right, and then the second question, if you are planning to take the MPRE, are you planning to do so in March, August, or November, or have you not yet registered for the MPRE exam? All right, so it looks like we actually have students planning to take this in March and in August, as well as November, and some who are not yet registered. So with that said, Professor Leigh Scales, I think that gives you a better idea for your audience for today's webinar, and I will turn things over to you.
All right, hello everybody. This is Professor Leigh Scales. I hope you're having a great day. And today we're going to talk about how to pass the MPRE. So the MPRE is the Multi-State Professional Responsibility Exam, and this exam is given in approximately 38 states, and you have to pass it in order to be admitted to the bar in those 38 states. If you would like to register to take the MPRE, all of the information is available at ncbex.org. That is where you would register to take the test and let them know what testing site you prefer. The registration fee is $95. If you register too late, however, the registration fee doubles. So I recommend if you're going to take it, register early. The exam is given 3 times per year in March, August, and November, and registration is already closed for the March exam. The test consists of 60 multiple choice questions, and each question has 4 answer choices. 50 of the questions count, meaning they're counted toward your score, and 10 of the questions are experimental. So what that means is they're testing the questions to validate them for a future exam, but they won't be scored on this exam. So you don't get any penalty for wrong answer, so I encourage you to answer every question. And if you happen to see like many questions on one area, then maybe it's because they're testing out some experimental questions. Or if you happen to see some questions that seem really strange to you, perhaps those are experimental questions. But you'll be scored out of the 50 questions out of the total of 60 that count. The exam is 2 hours long, so that means you have 2 minutes to answer each question. The exam is scored between the range of 50 and 150. And the passing scores vary by state, but generally you have to earn between a 75 and an 86 to pass. In California, you need an 86, and in Washington, you need an 85 in order to pass the MPRE. The MPRE covers 2 sets of rules. The first is the ABA Model Rules of Professional Conduct. And the majority of questions on the exam will come from the ABA Model Rules of Professional Conduct. Probably around 55% of the questions will come from the Model Rules of Professional Conduct. And those are the rules that govern lawyers. And the MPRE tests on the model rules, and then each state adopts the rules with any revisions that that state prefers. And the state rules are actually what are binding on the lawyers within that state. But for the purposes of the MPRE tests on the model code. So for purposes of the MPRE, you need to be studying the model rules of professional conduct. The MPRE also tests the ABA Model Code of Judicial Conduct. That is the code of conduct that governs judges. So there are usually around 5 or 6 questions from the Model Code of Judicial Conduct, so you definitely want to be familiar with that code as well. In order to pass the MPRE, you need to get between roughly 32 to 36 of the 50 questions that count correct. So depending on how easy or difficult the test is, the number can vary, but generally speaking, if you can get 32 to 36 correct out of the 50 that count, then you should pass the MPRE. All right, I see a question from the audience. It asks whether the exam is taken online or I need to be in the U.S. I am not certain of the answer to that. I would recommend you go on the ncbex.org website and look at frequently asked questions, or go to their contact information and call the National Conference of Bar Examiners to ask them. When you study, I recommend that you obtain a hard copy of the rules. So you can either print them from the links on the last slide, but they're fairly voluminous. Also, all of the rules have comments, and the comments are even more lengthy than the rules themselves. So unless you have a really good printer, I'm not sure you're going to want to print all the rules, but that is one option. Another option that might be easier for you would be to just go purchase a used version of the rule books from Amazon.com. You can usually get a book for about $5. So I would recommend you choose the Selected Standards on Professional Responsibility by Morgan and Rotunda. And typically you can find them online for $3 or $5 US. So that might make it easier for you than printing out all those pages. But either way, either print the rules from the websites or buy a rule book so that you have a hard copy of the rules, because they're lengthy and you're going to want to be able to make notes on them and highlight them and so forth. So I recommend that you get a hard copy of the rules. All right, so how to prepare for the MPRE. If you are in one of Florida Coastal's PR courses, then I would recommend you study the slides that are provided in the course. Also, study the rules that are in the ABA model rules of professional conduct and the judicial code that I mentioned. You need to study the rules and all the comments. The test examiners love to test you out of the comments, so be sure to study the comments to both sets of rules. Also, review the practice questions from your PR course, assuming you're a Florida Coastal student. Also, if you're a Florida Coastal student, you have free access to MPRE's MPRE course, so I recommend you go to barbary.com and sign up. If you're not a Florida Coastal student, then you could contact Barbary and see whether the course is free or what they would charge you. Many of the bar review courses will give you a free MPRE course in order to introduce you to their products. So you can try Barbary and see if they're willing to do that if you're a non-FCSL student. If you are an FCSL student, then you do have access for sure. When you sign up for the Barbary course, you'll have access to an outline of all of the professional responsibility materials. So in order to prepare, you certainly want to study the outline. And while you're reading the outline, as you come to each rule and its comments, I recommend you then leave the outline and go read the actual rule and its comments, and along with the Barbary outline. The next thing you may want to do is watch the Barbary review video. If you're a Coastal student, you'll be sent a link, or if you have access to the Barbary MPRE online review course, the review video is a part of that online course as well. So Paul Lisnick does a really good, approximately 3-hour review, and I recommend that you watch that as well when you're preparing for the MPRE. There's also an outline that you fill out while Mr. Lisnick is doing the review, and I recommend that you fill out the outline, and if you're a Coastal student, we will email you the outline after the presentation. Also, I have written my own outline of the professional responsibility course and all of the rules, which I named the Golden Ticket after Charlie and the Chocolate Factory. So if you are an FCSL student, you will be emailed my Golden Ticket. And so that's my outline I've made of the course, which students have said they found very helpful. All right, so also to prepare, you want to do as many practice questions as you can, and I would recommend a bare minimum of 600 questions. There are many resources where you can access free practice questions. On Barbary, Kaplan, and Themis are 3 major bar review companies, and as I said, I believe most of them offer their MPRE review courses for free. So go on those websites and click on MPRE review course and see if they are free. Also, there's a website and an app called BarMax. It's an app only on iPhones and iPads. It doesn't have an Android version at this time, but you can go on your personal computer and just Google BarMax MPRE, and they have a free program that includes free practice questions. What BarMax does is it divides the topics into about 10 topics and does a short presentation about the topic and then offers practice questions on that topic. Also, if you go online and Google Regos MPRE, that's a free review site that has practice questions, as well as rongolini.com has free MPRE practice questions. So those are all places where you can get review materials and practice questions to prepare you for the MPRE. And the more practice questions you do, the better you're going to do on the MPRE. The ncbex.org website, which is the website that you go to register for the exam. That's the National Conference of Bar Examiners. That's where you go to register for the MPRE and for other bar exams. If you'll go on ncbex.org and click on MPRE, the ncbex.org MPRE section has 15 free practice questions. I definitely would recommend you do those. And also you may purchase, and I've put the link there to get to those free practice questions. You may also purchase a full practice test on the ncbex.org website in the study aid store, and that's $35. I highly recommend you purchase that test and do that practice test as well prior to taking the MPRE. All right, so let's talk about the substance of the rules now. So what I'm going to do for the remainder of the presentation is just go through an outline of professional responsibility law that is likely to be tested. Certainly there are more issues than I can get to in this presentation, but I'm going to hit the most often tested topics. And then after that, you can go on and, study even harder and with much greater detail to prepare yourself for the MPRE. But this will give you an idea of the kinds of content that will be tested. So first, when you read the rules, they'll typically say whether an attorney or a judge must do something or may do something. Please be sure to note whether the rule says that you must or shall do something or may do something. If it's must or shall, you may be disciplined by your state bar for failure to follow a rule. But if the rule says may, then it is within the attorney's discretion and you will not be disciplined for your decision whether to do something or not. Okay, hot topics. So the rules are numbered 1 through 8, and then they each have subtopics. So I'm just going to start with 1 and hit the hot topics in chronological order. So first, let's talk about attorney competence. All right, so the rule states that attorneys must be competent, and what that means is that we must have enough knowledge and skill in order to properly represent our clients. If you're not competent in an area, you can become competent through self-study, meaning just study the area and become competent yourself, or you can associate with counsel who are competent. So basically team up with another lawyer who's competent and kind of have them show you the way. Next rule, 1.2, allocation of authority. This rule states how authority is allocated between a lawyer and the client. And what the rule says is that the client gets to determine the objectives of litigation, such as whether to settle a case, whether to plead guilty or not guilty, and the lawyer gets to determine the means of achieving those objectives. So those would be the day-to-day decisions, such as maybe what discovery request to file, or what actions to take in order to further the objectives, which would be to go to trial or settle or something like that. Now, if there's a decision that needs to be made that's going to involve spending money, typically the lawyer should defer to the client. So for example, if the lawyer wants to take depositions that are very expensive or hire an expert witness that's going to be very expensive, then usually the lawyer will defer to the client on spending that money. All the rule says regarding if the lawyer and client don't agree on the means of achieving the objectives is that they should seek a mutually acceptable resolution. So the rule doesn't really tell you how to resolve that if you and your client are in dispute over the means of achieving your objectives. The rules say if you're in conflict enough, then of course the client can always fire the lawyer or the lawyer can withdraw. All right, next, 2 rules that govern the fees that lawyers charge are rules 1.5 and 1.15. 1.5 basically says that any attorney's fee must be reasonable and not excessive. And Rule 1.5 gives the factors for reasonableness, such as customary fees charged in your jurisdiction, the difficulty of the matter, the skill level of the attorney, and so forth. And basically, if you get any fee question on the MPRE, you're going to want to make sure that the fee isn't excessive. Also, 1.5 states that contingent fees must be in writing and signed by the client and must outline what the fees will be and how any fee will be split between the lawyer and the client. Only contingent fee agreements must be in writing. Other types of fees, such as hourly fees or flat rate fees, do not have to be in writing. But contingent fees do have to be in writing, and they have to explain how any recovery will be distributed between the lawyer and the client. So for example, if there are costs that have been incurred, are those coming out of the lawyer's portion or the client's portion or both? And whatever agreement you want to reach with your client as to the payment of expenses related to litigation or a case are fine. You just need to outline them clearly in your contingent fee agreement. Also, 1.5 tells us that you can't charge a contingent fee in a criminal law matter or in a divorce family law matter. So you can't tell a criminal defense client, hey, if we win and I get you acquitted, then you have to pay me, and if we lose, you don't. That would be a contingent fee, and that's against public policy. Also, a contingent fee can't be based on the amount of alimony, child support, or property you secure in a divorce. They don't want attorneys having a personal interest in that because it's against public policy. So no contingent fees in criminal law matters or in divorces. Now, if after a divorce is over, one party is supposed to pay and over time they don't pay, and let's assume a $50,000 or some amount of arrearage is incurred, then a lawyer can go and collect the arrearage based on a contingent fee. That's considered more like a collections case. So it's just no contingent fees in the original divorce. I see an answer about the test locations. The MPRE is administered in over 300 test center locations, and then there's a link on the screen that gives additional information. So perhaps it's given outside the United States, but you could check the link to find out for sure. So thank you for that. All right, Rule 1.6, client confidentiality. This is a heavily tested rule. And it basically states that a lawyer shall not reveal information relating to the representation of a client. So that's really broad. That means anything your client tells you or anything at all that you come to know by virtue of the fact that you're representing a client. So it could come from a third party. It could be something you observe. So you can't reveal confidential information unless there are 3 exceptions present. Number 1, if the client gives you informed consent, then you can reveal confidential information. Number 2, if the disclosure is impliedly authorized in order to carry out the representation. So for example, if you needed to go ask maybe a mentor for advice on how to better represent your client, or you wanted to go talk to an expert witness, or you want to negotiate a settlement or talk to a doctor, to see if a client needs a guardian. There are often things you need to do in order to carry out representation of your client. For instance, you've got to be able to talk to opposing counsel, and you can't go and get the client's consent every single time necessarily. So anything you need to do in order to better represent your client, then you can breach confidentiality in order to do so. Now, let's say you need to go get an opinion from another lawyer about, the best way to handle a certain legal issue. The best idea is to not reveal your client's name when seeking that information, but present it in a hypothetical. So that's a way to kind of get the information you need to effectively carry out the representation without necessarily breaching your client's identity. Also, you can reveal confidential information if it's permitted under 1.6b. So 1.6b has 7 exceptions, and I'm going to run through each of them. So you can reveal confidential information in order to prevent reasonably certain death or substantial bodily harm. So that means if you learn either from your client or from anyone that your client is going to harm someone, then you may reveal that. So you can tell the potential victim or the police or whoever you want to, hey, I think there's going to be harm done here. But you know what? If you choose not to, you don't have to. So it's a may rule, not a must rule. So you may reveal information in order to prevent someone from being harmed, but you don't have to. B2 says you can reveal information to prevent a client from harming the financial interests or property of another, but only if, so there's an extra qualifier on this one, only if the client has used your services in furtherance of harming the person. So for death or bodily harm, the client doesn't have to have used your services in furtherance of the harm, and you can still reveal it if you would like to. But if it's financial harm, then you can only breach confidentiality and reveal it if the client gives you if the client has used your services in furtherance of the harm. Next, if you need to secure legal advice about the lawyer's compliance with these rules. What this means is if you have a legal ethics question, you're not sure if an action you're planning to take is ethical or not, you can breach the ethics rules to get an opinion on that. Again, it's a good idea to couch it in hypothetical terms, but technically if you want to give your client's name, you can, and you will not run afoul of the rules. All right, number 5. If you get into a controversy between yourself and a client, so a client says, I'm going to report you to the bar, or I'm going to sue you for malpractice, or I'm going to turn you over for criminal prosecution. From the moment the client makes the allegations against you, then you can breach confidentiality in order to defend yourself. You do not have to wait until the formal claim is filed. Rather, from the moment the allegation is made, you can breach confidentiality in order to defend yourself. Next, you can also breach confidentiality to resolve conflicts of interest. You see that under subpart 7. So let's say you move to a new firm and you need to make sure none of the clients that you represented at your old firm are being represented on the opponent to those old clients isn't being represented by your new firm. So you can bring your client list and a description of the matters to your new firm to resolve conflicts of interest issues and make sure you're not moving from one side of a case to a firm that's on the other side of the case. All right, the next area that's really heavily tested are conflicts of interest. So all the conflicts of interest rules are found in 1.7 through 1.12. So 1.7, 1.8, 1.9, 10, 11, and 12. So we'll start talking about 1.7. This is conflicts of interest among current clients. So basically, you should not represent one client who is directly adverse to another client. And also, you shouldn't represent one client if there's a significant risk that the representation of that client will be limited by your responsibilities to anyone else, be it yourself, your spouse, a current client, or a former client. You can't represent a current client against another current client, even on an unrelated matter, without the client's consent, because you shouldn't be representing a client and then suing that same client for a different matter without the client's consent, because the client's probably going to feel like you're not loyal. So in order to represent a client in one matter and then sue them in an even unrelated matter, you would need the client's consent. And the only conflict that's not consentable is you can't represent a client against another client, current client, in the same matter, even with consent. It's not consentable. So basically what that means is neither you nor members of your law firm can be on opposite sides of one case. That's not consentable. But it's possible that you could represent a client, let's say, in an adoption issue, and then be suing that same client in a totally unrelated tax issue, so long as you could get the client's consent. But you couldn't be on both sides of a tax issue or any similar case. Neither you nor your firm can be representing both sides of that matter. That's a non-consentable conflict. Now, if there's an apparent conflict, so for instance, you represent a client in an adoption matter and you or someone else in your firm wants to sue that client in an unrelated tax matter, you may do that if you can meet the requirements of 1.7b, which are number 1, you've got to reasonably believe you can provide competent representation to both clients. So that would mean your client in the adoption matter and the opposing party who's opposing your client in the tax matter. But if you believe you can reasonably and competently represent both of them, and the representation, again, doesn't involve the assertion of a claim by one client against another in the same proceeding, so they're different proceedings, and you can get informed consent, then you can do it. So if they're unrelated matters and you can get consent, then you can waive the conflict. If they're related matters, then you can't even get consent. You and your firm members simply can't be on opposite sides of the same or similar matters. All right, next let's talk about former clients. Rule 1.9 governs conflicts regarding former clients. Basically, if you have represented a client and you learn things about them while representing them, then you can't later sue that client or go against that client, be adverse to that client in any way, and use that information that you learned while previously representing the client against the now former client. So for example, let's assume you represent a guy named Joe in a divorce and you learn that he has offshore accounts hidden in the Cayman Islands. Later, a creditor comes to you and asks you to sue Joe, who's now your former client. Let's assume his case is over. And the creditor wants you to sue Joe. You can't do that because you know from representing him in his former divorce that he has money hidden in offshore accounts. And because you could use that information against him in the lawsuit brought by the creditor, you can't take on the representation of the creditor. You've got to remain loyal to your former client, Joe. But if the second matter where you're suing Joe was completely unrelated to the first matter, then you can represent the second client. Simply because you've represented someone in the past doesn't mean you and your law firm can never be adverse to that person again, especially if it's a big corporation. Let's say you represented Coca-Cola. That doesn't mean that for the rest of time, neither you nor the other members of your firm can be adverse to Coca-Cola. You simply can't in a matter where whatever you learned in the first representation of Coca-Cola could be then used against Coca-Cola later when you're adverse to Coca-Cola. All right, 1.9b tells us that if you move to a new law firm, so you get a new job at a new firm, we'll call it Firm 2. And your old firm, which we'll call Firm 1, was on the other side of a case from your new firm, Firm 2. So on Firm 1, that firm was on one side of a case. Firm 2 is the opposing counsel in that same case. Okay, if you as the attorney received confidential information about the case while at Firm 1, so meaning probably that you worked on the case, then when you go to Firm 2, who is on the other side of the same case, or a substantially similar case would qualify as well, you can't work on the case at Firm 2 without the client's consent, the Firm 1 client's consent. However, if you didn't work on the case at all and have no confidential information about the case, then when you move to Firm 2, you can work on the case. There's just no conflict because you don't know anything. So there's no problem. Now, if you're conflicted out, then does that conflict go to your new firm? So let's assume you move from Firm 1 to Firm 2 and you're conflicted out because you worked on the case while at Firm 1. So even though you're conflicted out, your other firm members at Firm 2 who are in the case when you arrive at Firm 2, your other firm members can work on the case, but they've got to screen you out is the rule. So screening is going to always help Firm 2. That if you come into Firm 2 with a conflict, Firm 2 can screen you out, and then the other members of Firm 2 can go along with the representation. And screening means that the requirements are on this slide. Screening means that you give the affected client written notice that, hey, this lawyer has come into our firm and he worked on this case or had confidential information about your case while at the prior firm. And then you tell them that the new lawyer won't have access to the files, won't talk to any of the lawyers about the firm or about the case, that the client can seek review by the court if the client isn't comfortable with the screening measures, and that the conflicted lawyer who's screened out won't share any part of the fees or profits from the case. So therefore, that lawyer shouldn't have any financial incentive to harm the client from Firm 1. Also, if an attorney is screened out and the conflict is personal, examples of that would be an attorney cannot represent a case if the attorney's parent, siblings, or children are involved in the case on the other side. So either they're opposing counsel or they're the opposing party. That's a personal conflict. So for instance, I couldn't represent a party in a case where my mother was opposing counsel, or my sister or my dad or my child was opposing counsel or was the opposing party. I would be conflicted out, but it's a personal conflict and it's not imputed to the other members of my firm. So other members of my firm could represent a client where the opposing counsel was my mother or child, for example, but I just couldn't. So that would be a conflict that wouldn't be imputed to my firm, because generally all conflicts that any lawyer in a firm has are imputed to the other members of the law firm, unless they're personal conflicts. There's another rule you're going to learn that says that unless you were having sexual relations with your clients before they hired you to represent them, you can't start having sexual relations with a client while you're representing them. But that's a personal conflict. It wouldn't be imputed to the other members of my firm. So even though I'm not allowed to have sexual relations with my clients unless I was already having relations with them before they hired me, for instance, if it's my spouse and I were already having sexual relations with my husband and then he hires me to represent him, that's fine. But if I meet a client and then later want to start having relations with them, I can't do that while I'm still representing the client. But that's a personal conflict that wouldn't be imputed to the other members of my firm. So I would need to get out of the case, but the other members of my firm could represent my client, and that would be fine. 1.10b provides that if a lawyer leaves a firm or dies, and therefore the cases leave the firm, either they go with the lawyer to the new firm or they go elsewhere after the lawyer dies, then the question is, can the firm that the lawyer was at when the lawyer left or passed away, can the lawyer's prior firm that the lawyer left through death or departure, can that firm go against the lawyers who left's clients? So assume the lawyer leaves and takes all his clients with him, or the lawyer dies and all his clients go elsewhere. Here's what the rule is. If anyone was left behind at the departed lawyer's firm who had confidential information about the cases, meaning they probably worked on the cases, then the old firm can't go against those clients who've now departed without the client's consent. Okay? But if there's nobody left behind at the old firm who knows anything about those cases that have now departed the firm, then the old firm can be adverse to those clients who left, because there's no problem there. Nobody left behind knows anybody about the cases. Every lawyer who knew anything about the cases has departed, so there's no conflict. But if anyone's left behind who knew about the cases, then the only way that the old firm can be adverse to those clients who left is for the clients who left to give consent. Screening will not resolve this matter. Screening only helps firm 2 when a lawyer comes into firm 2 who happens to be on the other side of cases the lawyer worked at firm 1. Then you can screen out the lawyer who is new to firm 2, and the firm 2 can just carry on with its cases. The second situation is different. If the cases leave firm 1, then screening doesn't come into play. Rather, the firm would need to get the consent of the clients who've departed firm 1 in the event that anyone's still left behind at firm 1 who knows about the cases. And if nobody's there, you don't need consent, you have no conflict, you have no problem. So it all really is common sense if you think about it, as to what to do in these conflicts of interest circumstances. All right, next, Rule 111 and 112. These rules are similar in that they both state that when a former government attorney or a judge, a judicial law clerk, or an ADR neutral, that means alternative dispute resolution, like an arbitrator or a mediator, if they work on a case and then leave and get a new job, okay, they can't be involved in a case that they formerly participated in personally and substantially. I call this the PPS rule. So if a former government lawyer or a judge, judicial law clerk, mediator, or arbitrator participated in a case and then they leave that job and go get a new job, they can't then go and continue to be involved in that same case unless they get the client's consent. Then the next question is, can their new firm be involved in cases that they were involved in at their prior employment? Again, screening is going to resolve this matter for the new firm. The new firm, yes, can be involved in these cases. They've just got to screen out the now disqualified lawyer. Make sure that lawyer gets no part of the fees and doesn't talk about the case, have access to the files, or anything like that. So let me give you a couple examples of this. Let's assume an attorney works for the IRS and they're suing Jane Doe to collect taxes. The attorney leaves the employ of the IRS, and then Jane Doe wants to hire that same attorney. Well, that wouldn't be permissible under the rules because the attorney participated personally and substantially in the matter while at the IRS. And so therefore, they can't represent Jane Doe against the IRS because it's the same or substantially similar matter. The next example, let's say while you're a government employee, you draft some legislation, and then you go out on your own and a client wants to hire you to challenge that legislation. You actually can do that because the rules consider the legislation to not be the same matter, okay? It's just you drafted some broad legislation that applies to a lot of circumstances. You can later challenge that legislation on behalf of a client because it's not considered to be the same matter. Same matters typically involve specific parties or specific parcels of land that you had to deal with, or things like that. All right, Rule 1.3, the must-may rules. So Rule 1.3 says that if you have a client who's a corporation or an organization, and you find out that someone within the organization is violating the law in such a way that is going to harm the investigation, then you must do the following. You must report to a higher authority, for instance, your boss maybe, or maybe the vice president or the president of the company. Then you must, second, go to the highest authority, which typically is the board of directors. They tend to be the highest authority in organizations. If you go higher and then you go highest, you must do both of those things in order to try to protect the organization, because remember, when you have a corporate or organizational client, your loyalty is to the corporation or the organization and not to any individual member of the organization. So if you find out somebody is violating the law in a way that's going to harm the corporation, you must go higher, you must go highest, and only then may you tattletale outside the organization and reveal the problem outside the confidential setting of the organization. So the rule says after you've gone higher and then highest, if those folks don't do anything to protect the corporation, then you may report outside the corporation to others as necessary in order to protect the corporation. Similarly, the Sarbanes-Oxley Act, this is an act that was passed after the Enron scandal, in order to protect companies that are publicly traded through the Securities and Exchange Commission. So if you're involved in a company that is traded on or involved with the Securities and Exchange Commission, and you find out that an employee of the company is doing things to harm the company or the stock, then you may, but to whom you go is a little different. You first must report the wrongdoing to the Chief Legal Officer, the CLO. Then, if they don't remedy the situation, you must report to the board of directors or to some component of the board of directors or to the board of outside directors. If the board doesn't do anything, then you may report the wrongdoing to the SEC. So again, they make you go up inside an organization to the very top before the rules allow you to report out. And then the reporting out duty is a may duty, so it's discretionary. You may report out, but you don't have to. Also, Rule 1.13 doesn't apply if you are hired to investigate or defend an organization. So let's say there's a new president in an organization and they think there's some wrongdoing. So they hire you to investigate and you find out indeed there is wrongdoing. Because you were hired to do this investigation, you don't have the authority to report outside the organization in that circumstance. All right, next, we're moving into Chapter 3. Rule 3.3 governs our duties of candor to the court, meaning we can't be involved in perjury. We must be truthful with the court. What the rule says is that we can't offer testimony we know to be false, meaning we can't put our client or any witness on the stand or offer any documents into evidence that we know to be false. However, if we only reasonably believe testimony or evidence will be false, then it's up to us. We may offer the evidence if we want and not offer it if we don't want to. So we shall not offer evidence we know to be false, and we may refuse to offer evidence we reasonably believe to be false. So the key two standards here are know and reasonably believe. If you know things are false, nope, you can't present them. But if you're not sure, you just reasonably believe, then you can put on the evidence if you want to. The only exception to that is if you're representing a criminal defendant and you reasonably believe but don't know that the criminal defendant is going to lie on the stand. If you only reasonably believe it, but you're not totally sure, then and your client, the criminal defendant, wants to testify, you have to let them because they have a constitutional right to testify on their own behalf. Now, what if a client perjures himself or any witness that you've put on the stand perjures themselves? You have a duty to not be involved in questioning a witness in a way that will result in perjury. So you've got to remove yourself from this situation. And so the DWR rule comes into play. The first thing you need to do is dissuade your client from perjuring themselves, or if it's already happened, you want to persuade them to go back on the record and correct the perjury. So they could go back on the stand, or if it's a mediation or a hearing, they need to go back on the record and correct the perjury. If the client refuses to do that, then you withdraw, you get away from it. If that will cure the problem. If it won't, then you can breach confidentiality and reveal the perjury to the court. And your 3.3 obligations to have candor with the court trump your 1.6 confidentiality obligations. So what this means is if you know someone you've put on the stand has perjured themselves and has lied, then you can reveal that to the court, and you're not going to get in trouble for breaching confidentiality. Your duty to reveal perjury is a higher duty than your confidentiality duties under Rule 1.6. All right, 3.4, I call this the My Peeps rule. It says that you can only tell your peeps not to voluntarily talk to the other side. So we're not talking about when someone's subpoenaed or court ordered to testify. Rather, we're talking about when the opposing party comes around asking questions to your client. So you can only tell your peeps not to voluntarily talk to them. And your peeps include your client's relatives, employees, and agents. Former employees are not your peeps. So you can't tell a former employee of a corporate client not to voluntarily talk to the other side. Also, you can't tell your peeps not to talk to the other side voluntarily if it's going to harm them to refrain. So for example, let's say your client is being investigated for child abuse and she lives with her sister. If the Department of Children and Families comes around and wants to talk to the sister, and the sister feels like she needs to voluntarily talk to them in order to defend herself from being accused of being the abuser, since she lives there in the house as well, then you can't tell the sister not to talk to the other side if it's going to harm the sister to refrain. Also, 3.4 says you cannot conceal or destroy material with potential evidentiary value. So I call this the PEV rule. If a case is going on, let's say your client's a dishwasher manufacturer and their dishwashers are blowing up, okay? And they say, hey, can we destroy all the documents that would show our manufacturing defect? No. Even if no cases have been filed yet, if you know those documents have potential evidentiary value in the future, you can't tell the client to destroy them or help them destroy them. Also, 3.4 is kind of the play nicely in the sandbox, play nicely on the playground rule. And it also says that you can't make frivolous discovery requests, and you must comply with non-frivolous discovery requests appropriately as well. All right, Rule 4.3, dealing with unrepresented persons. This rule tells us that if your opponent doesn't have a lawyer, then you cannot imply, you cannot imply that you're disinterested. Now, I did not make up that wording because, as you can see, it's a double negative and I think it's confusing. The rule says you cannot state or imply to the unrepresented opponent that you are disinterested. What that means is they've got to know you're interested, meaning that you are on the other side, that you are not representing their interest. You're only representing the interest of your client. So they need to understand that you do not represent their interest. So typically, a good example is in a divorce case, let's assume you're representing the wife and the husband decides not to have an attorney. Okay, if you're talking to the husband to try to settle the case, you've got to make sure the husband realizes that you don't represent his interests. You're not his attorney. Rather, you only represent the interests of his wife. Now, let's assume you guys reach a settlement agreement, and so you draft the divorce decree. When you send it to the husband, I recommend you send a cover letter that states that you represent the wife's interest and not the husband's interest. Also, Rule 4.3 says you can't give legal advice to the unrepresented person. You can tell the other represented person to seek counsel, but you don't have to. So you can't give legal advice, and the rule also states that you can tell the unrepresented opponent to seek legal counsel, but you don't have to. That's up to you. All right, let's talk a little bit about advertising and solicitation. This is a heavily tested topic on the MPRE. So under 7.1, any communications you make about your services cannot be misleading. So for example, you can't guarantee results. You can't say, well, I've won 3 jury trials of over $1 million each, because that might mislead the public into thinking that you can guarantee you can get $1 million for them too. If you want to say that you won $1 million for a past client, you would need to include a disclaimer that those results vary by case and can't be anticipated. Also, other things that can be misleading. You can't, for instance, show yourself in a commercial arguing before a jury if you've never had a jury trial. That would mislead the audience to believe that you have jury trial experience when you don't. Also, you can't say that you're the best or least expensive attorney and make comparisons of yourself with other attorneys like I'm the best, unless you can objectively substantiate that with data, which would be impossible. So avoid comparisons with other attorneys that you're the best and so forth, because that's misleading. All right, advertising. You can't pay referral fees to other lawyers or people, anyone, for sending you cases. So you can't have police officers or ambulance drivers or emergency room doctors who tend to be around people who are injured, handing out your business cards in exchange for you paying them, $100 per business card they hand out. So you can't give anything of value, be it money or your services, in exchange for getting referrals. So no referral fees. You can't pay ambulance drivers. You can't pay other lawyers. You can't pay anybody for sending you clients, with a few exceptions. You can pay normal ad costs in order to get clients. You can pay a not-for-profit or qualified lawyer referral service. So under Chapter 7 of the rules, I call this the N and Q rule. You can pay the usual charges to be on a not-for-profit lawyer referral list or a qualified, usually it's qualified by your state bar, lawyer referral list. Another way to get clients is you can participate in legal service insurance plans. So these plans go solicit people, and then if those people pay premiums, just like you pay for any type of insurance. And then if those customers ever need a lawyer, the legal service insurance plan provides a lawyer for them. The only restriction there is that the legal service insurance plan can't directly solicit clients they know are in need of a particular attorney. So for instance, the legal service insurance plan can't go down to the courthouse every day and look at all the new filings and see who needs a criminal defense lawyer, who needs a divorce lawyer, etc., and then target those people knowing they need a lawyer. The lawyer service insurance plan can only solicit in general. So they can go through the phone book and call everyone in a certain zip code, as long as it's a general solicitation to clients that are not known to be in need of a particular attorney. You can also obtain clients through reciprocal referral agreements, and there are 4 requirements. They can only be between a lawyer and another lawyer or non-lawyer professional. So, for example, you can refer clients to an accountant or a marriage counselor or an engineer or anyone who would be considered a professional, and they can then do a reciprocal referral to you. So they can send their clients to you, you can send your clients to them. But you can't do it with a non-professional, like someone who owns a pizza parlor. So you can't say, I'm going to send you pizza clients if you send me law clients, because that would violate the rule that it has to be a reciprocal referral agreement between professionals. Also, the agreement can't be exclusive. What that means is if you're referring to another professional, you need to be referring to more than one. You can't just have an exclusive agreement. You need to be referring to at least 2. The agreement can't be indefinite in nature. So what that means is every now and again, you're supposed to, look at the agreement and make sure it's still working in a beneficial way. And 4th, the client has to be informed that you are involved in a reciprocal referral agreement. So if you refer a client, let's say to a marriage counselor, you need to tell them, hey, that marriage counselor also refers clients to me, so that the client can judge your motivations. So I see a couple questions. We see advertisements on the interstate highway stating that they've won $1 million. Are these not misleading? Well, 2 things could be at play. One, in whatever state you're seeing those, which here it looks like is Florida, there may be a Florida rule that allows those, because again, remember the MPRE is testing only the model rules. Also, those billboards might have a disclaimer on them, assuming Florida requires such. Next, Kaplan has 2 4-hour MPRE lectures and a practice test and workshop on March 4th and 11th. Do you have any comment whether this would be worthwhile? Yes, that would be worthwhile. Any, Kaplan, Themis, Barbary, they all do good MPRE lectures, and they all have good practice tests, all 3 of them. All right, next, let's talk about solicitation. So you've got to differentiate between in-person solicitation and not in-person solicitation, or I guess a better way to distinguish it would be live solicitation versus not live solicitation. So if you're soliciting clients live, meaning in person, on the telephone, or via something like Skype, so you're live and you're putting some pressure on someone, hey, can I represent you? Because you're putting that pressure on them, the rule is you can't live solicit people in person, on the telephone, or on any kind of live, we have got all this new technology now, live interface like Skype, except you can solicit family and anyone you have a close personal relationship with, like close friends, other lawyers, and former clients. So you can walk up to any of those 4 groups of people and say, hey, can I represent you? But everybody else is off limits, because it could assert too much duress on them if you walk up or call them and they're kind of under pressure to say yes to you. Okay, so you can only in-person, live, telephone solicit family, close friends, lawyers, and former clients, because they figure they know you well enough to not feel under duress or to protect themselves. Now, you may solicit anybody you want to in an indirect or non-live way. So that would be via text, email, regular snail mail, or voicemail. So if it's not live, meaning they listen to it or open up your solicitation at their own leisure and they can respond or not. You can solicit any of those people so long as you state the words advertising material on the solicitation. So if it's a letter, the model rule says you have to put the words advertising material on the envelope. If it's a voicemail, email, or text, it must say advertising material at the beginning and at the end of the communication. And if you're soliciting in this indirect way, people listed on the slide, family, close friends, lawyers, or former clients, you don't have to put the words advertising material on solicitations to those people who you already know. Rather, you only have to put those words on solicitations to people that you don't know. Also, if you're just sending out a notice that you've relocated your office or changed your office personnel, those aren't considered solicitations, so they don't need to have the words advertising material on them. So if you just are sending out a notice that you've relocated your office to a new address, or so-and-so has become a partner or an associate with your office, then you don't have to write the words advertising material on those. So there's another question. I have a question on attorney's fees. What is the rule or guidelines on the attorney's fees? So you'd want to look at Rule 1.5, and it basically just says that attorney's fees have to be reasonable. And it gives a list of criteria the court would use to determine reasonableness, such as how difficult the case is, how skilled the lawyer is, and what typical fees are in your locality. It also provides rules about contingent fees, such that they have to be in writing, and so forth. The model rules, which are tested on the MPRE, don't get into great detail about fees, but each state, when that state adopts the model rules, typically adds a lot more detail to the fee rules. So whatever state you practice in, you would want to look at those rules. But for purposes of the MPRE, mainly you just need to know that the fee has to be reasonable. All right, next, 7.4, fields of practice. You can only say you're certified as a specialist in an area if you are certified by your state bar or the American Bar Association. So getting board certification is a very difficult challenge. It usually takes about 5 years at a minimum. So you can't say, for instance, that you're certified in tax law unless you really are. Otherwise, you can say you practice in any area that you choose to, or that your practice is limited to certain areas, and that's fine. Just be careful when saying you're certified as a specialist. Those are the words that are going to get you in trouble unless you've actually gone through board certification by your state or by the American Bar Association. 7.5, firm names. You can use trade names, so let's assume you're bald. You can say you're the Bald Lawyer Law Firm, and that's fine. If you're going to use a geographical name like the Springfield Legal Clinic, then you may need a disclaimer that you aren't a legal aid agency, because oftentimes it can be confusing to the public if you say, you know, you're the New York law firm. They might think that you're legal aid or that you're a public agency to help the poor. So you might need a disclaimer that says you're not a legal aid agency. Also, you can use the name of anyone who's currently in your firm or was formerly in your firm. So a lot of firms are named after partners who are deceased, and that's fine. You can't use the name of a public figure who isn't currently practicing in your firm. So if one of your partners has left to go be the governor or a judge or the president, and they're holding public office somewhere, then their name has to come off the door and off the firm name while they're not practicing with the firm. Rule 8.3, this is the tattletale rule. Lawyers are a self-policing profession, and Rule 8.3 says we must report misconduct of other lawyers that raises a substantial question as to their fitness to practice law. So we don't have a choice. A lot of times you won't want to tattletale on your peers, but if they are doing things and the standard is that raises a substantial question as to their fitness to practice law, then you must report them to the bar. Under 8.4, this states that we must be fit to practice law, and we can't engage in crimes involving dishonesty or fraud, or violate or attempt to violate the model rules. So interestingly, for crimes, we only have to forego crimes involving dishonesty or fraud. So tax evasion, embezzlement, things like that are off limits. But if you got one DUI or one prostitution charge, then chances are you wouldn't be disciplined because that's not a crime involving dishonesty or fraud. As far as violating the model rules, 8.4 says we can't violate or even attempt to violate the model rules. So even if you attempt to violate a model rule and you fail, you can be disciplined. Whereas the same doesn't hold true for crimes. All 8.4 says about crimes is that you're disciplined if you engage in the crimes, but you would actually have to be convicted of the crime. Just attempting a crime will not subject you to discipline. All right, now we're moving on to the Code of Judicial Conduct. So this is also tested, and this is the code that governs judges. The code is divided into 4 canons, and it's not terribly long. So I'm going to talk about the main provisions that tend to be most tested. So out of Canon 2, Rule 2.11 is often tested, and this is the rule that says when a judge must disqualify herself or recuse herself from a case. So first, if a judge is biased against a party or a lawyer, the judge must disqualify herself from the case. Then there are a whole bunch of other rules along the lines that if a judge or one of the judge's relatives is involved in a case, then the judge must move to disqualify herself. So if the judge or her partner or any relative within the 3rd degree, which is basically all the judge's relatives except their cousins, is a party, a witness, a lawyer, or a judge in the case, then the judge must reveal that on the record, tell the parties that, hey, you know, I'm a relative or my spouse is a relative of people involved in this case, so you might want to disqualify me. Then the procedure is that the parties go outside the presence of the judge and decide whether they want the judge to be disqualified from the case. If the parties want the judge disqualified, then the judge is disqualified. If the parties want the judge to stay on the case and the judge believes the judge can be impartial, then the judge can stay. The only exception being if the judge is biased against a party, the judge can't stay even if the parties wanted them to. So let me give you an example. Let's assume the judge's mother was in a Ford rollover accident and the judge feels that Ford Motor Company really mistreated the judge's family. And the judge dislikes Ford Motor Company to the extent he doesn't feel like that he can be impartial and fair to Ford Motor Company. That's a case of bias against a party, and the judge would have to disqualify or recuse himself. And even if Ford Motor Company consented to the judge staying on the case, the judge would be unable to do so because of the judge's bias. A judge should also disqualify himself in any case where he believes his impartiality might reasonably be questioned. So, even if someone coming in the courtroom is the judge's cousin, who wouldn't automatically be a basis for disqualification, if the judge is really close with his cousin, or maybe the judge's best friend is coming in the judge's courtroom as a party or a witness or a lawyer, then the judge, if there's any reason a third party might think the judge can't be fair, then the judge should put it on the record, let the parties know the basis for the potential problem, and let the parties decide if the judge should stay or not. Next, Canon 4 governs judges' political activities, and it basically says that judges cannot be involved in politics unless they are running for election to be a judge. So while a judge is running for, or a person, or a sitting judge is running for re-election, if someone's running for judge, they can be involved in politics just like any other politician, meaning they can campaign, they can go to fundraisers for themselves and for other candidates, they can give money to their own campaigns and to other candidates' campaigns, and do anything they want. But outside of that circumstance, judges cannot be involved in politics. They can't give political contributions, they can't attend fundraisers. Also, judges must resign from the bench if they're going to run for non-judicial office. So let's assume a sitting judge wants to run for attorney general or run for mayor or senator or whatever. The judge must resign while the judge is running for that other non-judicial office. Now, if a judge is running for judicial office, they can stay on the bench while they run because probably they're going to be reelected and then you won't have an interruption in their employment. Also, if a judge is up for an appointment, so some judges are appointed instead of elected. If a judge is being considered for appointment, the judge doesn't have to step down while they're being considered for an appointment. So if they're a sitting judge, but maybe they're being considered for appointment to a different court, then the judge doesn't have to step down while they're going through the appointment process, because the appointment process just isn't that time consuming. Also, another kind of overriding rule in the judges' rules is judges can't be involved in any activities that would take away from their ability to participate and take care of their judicial duties. So they can't be involved in any extracurricular activities that are going to take a lot of time and take them away from being able to preside over their cases. Also, judges have to avoid impropriety and the appearance of impropriety in their personal lives, and their judicial duties, their personal duties cannot take precedence over their judicial duties. Their judicial duties come first. So a judge is a judge first and can't be doing anything in the judge's private life that would interfere with the judge being able to preside over the judge's cases. So for example, a judge couldn't sit on a board of a company that often would be coming into the judge's courtroom for a case, because then the judge would have to keep disqualifying himself. So no extracurricular activities that would require a judge to commonly have to disqualify themselves from cases. All right, are there any questions?
Thank you, Professor Scales. That was an absolutely wonderful presentation, and it looks like you've answered the questions that have come in through the chat feature. I think we have one additional question that just came in. Can judges have an affiliation with a political party, and can they publicly support a political party?
No, judges should be nonpartisan. The only time they can be affiliated with a political party is if they're running for judge in a partisan race. So if there's a race that is open to all parties, so judges can run whether they're, for instance, Republicans, Democrats, members of the Green Party, then judges can't affiliate with a political party. But if a judge is running in a closed primary where only Republicans can vote, for example, or only Democrats can vote, in those partisan elections, judges can be affiliated with parties. But if a judge isn't actively running for election, then no, a judge cannot be affiliated with a political party.
Wonderful. Thank you, Professor Scales. And one final question on behalf of our LLM students. Can they take the MPRE while they are a student? And if the answer is yes, aside from taking your professional responsibility course, how much time should they plan in terms of preparing for the exam? And I know you provided some recommendations at the start of the presentation, but if you could summarize them here again, that would be great.
You know, probably if you would, study for this exam, for about a month before the exam, and really you'll be able to tell based on doing practice questions how familiar you are with the materials. So definitely you want to get an outline of some form, assuming you're not a coastal student. Get a Barbary outline or a Themis or Kaplan and make sure you're familiar with it all. And then the best way to test yourself is just start doing practice questions. There are so many free practice questions available out there. And you want to get to where you're getting, if you're taking practice tests that are 60 questions, which is the norm, you want to get to where you're scoring in the high 30s consistently, ideally even in the low 40s. And once you get to where on practice tests you're scoring, 38 or above, you can feel pretty confident that you're ready.
Wonderful. Thank you. Well, with that said, I will turn things over to Natalie Gill so she can wrap up today's webinar.
Thank you, Dean Ioannidis and Professor Scales. Please feel free to keep using the chat feature to type in your questions as we wrap up here. Our contact information is here, so please reach out to us with any questions that you may have. If you have any questions or would like to learn more about our LLM programs, please visit our website listed on this slide. And you can also find us on Facebook. And finally, I would like to extend an invitation for you all to join us for our next online events later this month on Thursday, March 16, 2017 at 12 p.m. Eastern Time. Professor Jeffrey Schmidt will be presenting on the topic, the constitutionality of President Trump's executive orders. Current LLM students, registration information is available in your LLM D2L class sites. Next month on Tuesday, April the 4th from 12 to 1 p.m. Eastern Time, our guest speaker for April is Professor Priester, and he will be giving a presentation on the California Bar Exam, Planning Ahead for Changes. For the registration link, visit our LLM events page on our website. And also, in addition to these webinars, Leah Fernandez, our international recruiter in admissions, will be conducting informational webinars for prospective applicants for LLM and certificate programs. So please visit our LLM events page on our website to register for any of these events. Please remember that if you cannot join us live, you can still get a copy of the slides and recording by simply registering for the event. Please don't forget to visit us on our Facebook page, U.S.A LLM and Logistics and Transportation, and give us a like. We'd also love to see any selfies of participants watching today's webinar. You may see some selfies from the LLM team already on the Facebook page, so please post your pictures on there as well. And with that, again, thank you to everyone who has joined us today, and to Professor Scales for taking the time to put together and share this amazing presentation. See you all at next month's Florida Coastal Online LLM Program Speakers event.